for those of you that have attended our in-person trainings, this is something similar to what he's done, but he's actually broken his session into 2 segments. And the first one is, as you can see, the statutory and contractual conditions for maintaining a foreclosure action, really. So hopefully this is helpful to folks. And Mike, as always, thank you for your help.
You're welcome, Becky. Hi, everybody. I just wanted to let you know briefly that I've been at Nassau Suffolk Law Services for 26 years. Since 2008, I've been the supervisor of our foreclosure prevention unit. And in addition to that, I also supervise our civil unit in Nassau County, where we represent tenants in summary eviction proceedings and in pre-termination hearings involving federal rental subsidy programs. With this webinar, I hope, we'll highlight the predicate requirements that plaintiffs in foreclosure actions must meet before the court gets to the central claim that plaintiffs are hoping they get to, which is to get a foreclosure judgment based on an allegation of a homeowner's default under the mortgage debt. So with that, I'll begin. The restatement of contracts defines a condition precedent as it qualifying a duty under a contract. Under the CPLR, Rule 3015, the performance or occurrence of a condition precedent in a contract need not be pleaded in the complaint, and therefore a denial of the performance or the occurrence must be made specifically and with particularity. So a general denial to paragraphs 1, 2, 3, 4, etc. of the complaint, or lack of knowledge and information sufficient to form a belief as to paragraphs 10, 11, 12 would not be sufficient. You need to affirmatively claim that the plaintiff did not meet the obligations for condition precedent under the contract, which I'll get to later on. However, any complaint that involves a high cost or subprime loan, as defined in the banking law, must contain an affirmative allegation that at the time the proceeding is commenced, the plaintiff is the owner and holder of the mortgage and note or has been delegated authority, and has complied with all of the provisions of the banking laws that are laid out there, Section 595, Section 6L or 6M, which go to the question of high cost or subprime loans, and also Section 1304 of the RPAPL, which talks primarily about the 90-day notice requirement. So the predicate conditions, if you go back to the prior screen, where the performance or occurrence of a condition precedent set forth in a contract need not be pleaded, the complaint must include some of the predicates that are required under the statutes. And with that, we go to the statutory condition precedents. And there are actually 3 sections. I only cite 2 in this PowerPoint. The first one is under RPAPL, Section 1303, and it's the notice that would be attached with the summons and complaint. And it's to the mortgagor, the owner-occupier, and also to the tenant. And it explains there that it's to be delivered with the summons and complaint in bold 14-point type on colored paper other than the color of the summons and complaint. And it should be on its own page. The statute also goes into some detail exactly the content of this notice. It primarily is to remind or encourage the homeowner/defendant to respond to the summons and complaint, advises them of their opportunity to seek assistance, and there are obviously most of the people I think on the webinar would be providing free services through the various programs funded primarily under the Attorney General grant in New York State, advises them to beware of scams, And then in addition to the homeowner, also advises the tenant that an action is taking place and what rights they may have if they have a lease. Section 1304 of the RPAPL is the section that requires a 90-day notice be served by the lender, the assignee, or the mortgage loan servicer at least 90 days prior to commencing the foreclosure action with the service of the summons and complaint. And this notice will basically tell the homeowner how many days the loan has been in default for, and advises the homeowner how much money they would need to pay by a certain date to cure the default. 1304 also tells how the plaintiff must serve this notice by registered or certified mail, as well as by first-class mail to the last known address of the borrower, and it must be in a separate envelope from any other mailing or notice. And the other important thing about that is the statute says that it's considered as given or delivered as of the date it is mailed. And this is important because a lot of other predicate notices in other areas of the law and under contracts, for the most part, are considered as given when received. So the homeowner would have had to have received that. But the law makes clear that that's not the case. As soon as the plaintiff complies with serving it by registered certified mail and also by first-class mail, that's when it's been served. The notice also has to contain a list of 5 housing counseling agencies in the region, and the notice need only be provided once in a 12-month period. So it's 90 to 365 days notice is effectively what it is, and it is not required for reverse mortgage. What I neglected to include in the PowerPoint is the new law that basically codifies into statute the certificate of merit, which was required initially back in 2010 through Chief Judge rules, which required affirmations by plaintiffs' attorneys at certain points in the foreclosure process, depending on when it was at, and that went to the robo-signing question. CPLR 3012-B now makes that, as I say, statutorily mandated, and it requires that the certificate signed by the attorney for the plaintiff that he or she has reviewed the facts of the case and that based on consultation with the plaintiff identified in the certificate and the attorney's review of the relevant documents such as the mortgage, the note, and any instruments of assignment, to the best of the attorney's knowledge, the plaintiff is legitimately the party authorized to commence this action. This certificate has to be served now as of the effective date was August 30th, so any actions that are filed after August 30th would require this certification to be included with the summons and complaint. So in addition to the notice required under 1303 of the RPAPL, which is the colored paper notice, they now have to add this attorney certification. And the other thing about this attorney certification that's required is that the attached to it has to be a copy of the mortgage, the note, and all instruments of assignment, unless those documents are actually attached as exhibits or just attachments to the complaint itself. So it would come at the same time, but if it's not attached, sometimes in complaints, a copy of the note and the mortgage, and sometimes I've even seen the assignments are attached to the complaint, then it would just be the attorney certification that would be added. If, however, none of those documents or not all of those documents are added to the complaint, it now has to be attached to the attorney certification certificate of merit that's required. The other point I wanted to make about this section, and I apologize for not including it in the PowerPoint since it was so new, it just escaped my mind that it would be a condition precedent. But Section E of 3012-B states that if the plaintiff willfully fails to provide copies of the papers and documents as required under this certificate of merit, then the court may dismiss the complaint. And where that language is actually significant and I think actually helps the plaintiff, as you'll see in a little while, is the cases generally make clear that the failure to serve a predicate notice, regardless of whether it's willful or not, can result in dismissal of the action. So here, with the certificate of merit that's now required, if the plaintiff's attorney fails to include the papers and documents that the statute sets out as required, only if it's willful, I believe, will the court rule, dismiss the action. Okay. So the next slide is a case that was decided by the Second Department Appellate Division in 2010, and it involves what happens where the plaintiff failed to comply with the notice requirements of RPAPL 1303, which is the colored paper notice. And the particular question that was before the Court of the Second Department in that case was whether or not the plaintiff's failure to comply with the notice requirements, whether it needed to be raised as an affirmative defense at the time the answer is due, or whether it could be raised at any time during an action. The court held that, in fact, the plaintiff's failure to serve the 1303 notice can be raised at any time during the action. In this particular case, the plaintiff did not establish that it served, that it attached the 1303 notice with the summons and complaint as required. The plaintiff did put in an answer, but did not raise this failure in his answer. When the plaintiff made a motion for summary judgment, with establishing it through the note, the mortgage, and evidence of the default, the defendant's counsel, in opposing that motion for summary judgment, argued in his affirmation that the RPAPL 1303 notice is mandatory and therefore the proceeding must be dismissed. The court went through the history of the Home Equity Theft Prevention Act and particularly its purpose in affording homeowners greater protections in the foreclosure process. And the court noted that HOPP's notice requirements has been consistently interpreted as a mandatory condition or condition precedent. And the burden of establishing compliance sits with the plaintiff from the outset. And therefore, if it fails to comply, dismissal is compelled. Just a preliminary note about this, HEDPA is actually codified primarily at Real Property Law, Section 265-A. However, some of the amendments, 1303 was amended, and that's it was amended at the same time as HEDPA was created. The court then went on and cited with approval to other areas of law where there are statutorily mandated notice requirements. So, for example, in summary eviction proceedings under the vehicle and traffic law, and filing notice of claims involving actions against a state or government office. And all of these situations resulted in dismissal of actions where the statutorily mandated notice requirements were not met. the court stated where the statutory language is mandatory, for example, shall, a condition precedent which is the plaintiff's burden to meet and which does not have to be raised as an affirmative defense in the answer can be dismissed at any time. Since RPAPL Section 1303 notice is not part of the complaint, although it is served with it, an affidavit of service that includes a description of the required content will, absent evidence to the contrary, be sufficient. And in Silver, the plaintiff did not, in its affidavit of service or in a separate affidavit of service, include such a description and did not claim that it was served, so therefore the court dismissed the action. Aurora Loan Services versus Weisblum actually involves primarily its benefit. It talks about the 1304 90-day notice. However, it also addressed a question involving the 1303 notice. And in this particular case, the plaintiff served the 1303 notice, required notice, with all the required content. At the same time, it served the summons and complaint, and it made this known in its affidavit of service, unlike the plaintiff in Silver. Unlike the defendant in Silver, the defendant in Weisblum actually included in their answer an allegation that the plaintiff failed to comply with RPAPL Section 1303. In their cross motion for summary judgment, one of the two homeowners, their husband and wife, and I believe it was the wife, averred that she did not receive the 1303 notice and contended that the copy of the notice affixed to the plaintiff's motion for summary judgment was on white paper in contravention of the statute's edict for color paper. Now, of course, the statute's edict is that it be colored paper, served with the summons and complaint. However, the court basically ruled that the plaintiff satisfied this burden through its affidavits of service. And the defendant's bare and unsubstantiated denial of receipt was insufficient to rebut the presumption of proper service created by the affidavits of service. And that's, frankly, a trend I've seen when in other areas and even in foreclosure actions where defendants will allege that they did not receive the pleading, even in the way it was supposed. They either didn't get it at all, or if they got it, they didn't get it under the methods of service required by the CPLR. And I have seen courts generally kind of ignoring those conclusory allegations by defendants in those situations. If a defendant is going to claim they did not receive a document that's required to be served on them, or they didn't receive it in the method and manner that it was required to be served, they would have to provide some factual support, I believe, for it. What's interesting about Weisblum in comparison to Silver is, is the dynamic of how this works procedurally. And as we go through the webinar, hopefully you'll get to see more of this. In that, as I said, in Silver, the defendant did not include an affirmative defense of noncompliance with 1303 in their answer, whereas in Weisblum, the defendant did include an affirmative defense in their answer that 1303 wasn't complied with. Yet, the Second Department, the same appellate division court, actually ruled in favor of the defendant in the action where they didn't raise it and rejected their claim in the action that they did. It goes to the sort of the procedural issues that are involved in that. However, Aurora Loan Services versus Weisblum was also actually favorable to homeowners on the issue involving proper service of the 1304 notice. The court held that the 1304 notice is a condition precedent, and plaintiff's failure to establish that it complied with the statutory predicate compels dismissal of the foreclosure action. This was a strict compliance that the court held against the plaintiff. In this particular case, the plaintiff actually did address a letter to the borrower at the premises more than 90 days prior to commencing the foreclosure action. And the notice contained all the statutorily required language, except it did not include a list of at least 5 housing counseling agencies. However, the plaintiffs did not submit an affidavit of service establishing the content of the notice and its enclosure, if any, or the manner in which and to whom the notice was mailed. In their answer, the defendants did assert that the plaintiff failed to comply with the 1304 notice requirements. When the plaintiff made a motion for summary judgment, at that point, it contended that it properly mailed the notice to the borrower, but not to his spouse. And there was some question. There was this particular case involved a consolidation and extension mortgage agreement in addition to the original note and mortgage, and the spouse, Patty Weisblum, was named as a borrower in that SEMA, but Stephen Weisblum was the only borrower on the original note. Stephen Weisblum, in his affidavit in opposition to the motion for summary judgment, averred that he did not receive the 1304 notice by registered or certified mail, and Patty Weisblum averred that she didn't receive it at all, as I say, even though she was identified as the borrower in the SEMA. The defendants, probably most effectively in their opposition, noted that the plaintiff failed to submit affidavits of service establishing compliance with the 1304 notice on both of the borrowers, Patty and Stephen Weisblum. The court stated that Section 1304 contains specific mandatory language consistent with the underlying purpose of HOPP, a nod to the Silver Court's decision, to afford greater protections to homeowners. The content, timing, and service provisions of 1304 are very specific and couched in mandatory language, and with regard to the manner of service, 1304 is equally precise. The court stated that the plaintiff bears the burden of establishing that the condition was by sufficient evidence, regardless of the opposing papers, met. And the court cited to a Court of Appeals case, Weingrad versus NYU Medical Center from 1985, that states the proponent of a summary judgment motion must make a prima facie showing of entitlement to judgment as a matter of law, tendering sufficient evidence to eliminate any material issues of fact from the case. The failure to make such a prima facie showing requires denial of the motion regardless of the sufficiency of the opposing papers. The thing that's important, maybe the most interesting thing about this particular statement by the Second Department is it makes clear that, to me at least, that the 90-day notice requirement is part of the plaintiff's prima facie entitlement to a judgment as a matter of law. And obviously at this point, you know, the plaintiff in seeking a summary judgment is looking to ultimately succeed in foreclosure. So that becomes very important to me. The court noted that there were multiple problems with the 1304 notice in this particular case. It was only sent to one of 2 borrowers. It did not include a list of housing counseling agencies. and it did not establish service by registered or certified mail and regular mail. The court rejected the plaintiff's contention that the defendants were not prejudiced by these failures, and the court stated, whereas here the condition sought to be disregarded is a mandatory condition precedent, the plaintiff's failure to comply cannot be disregarded. Aurora's substantial failure to comply with 1304 cannot be deemed a minor irregularity which can be overlooked. The court declined to set forth when, if ever, a single violation in a 1304 notice might be so minimal as to warrant the exercise of the court's discretion to avoid dismissal of the action. Basically, it seems to me that, I guess the court is left for another day the question of whether one failure, for example, the failure to list 5 housing counseling agencies, or failing to serve it in a particular way, or failing to have some of the other content, the amount owed, that could cure the default and the the time in which to cure it, whether any of those by themselves the court would ignore that defect and allow the case to proceed. I hearken back to the fact that consistently in both these cases that I've cited so far and in other cases, it is very clear that there is strict compliance required with the statutory notice requirements. And that's true in other areas of law as well. And I believe that any one violation would be sufficient to compel dismissal, similarly with the same result that was in this particular case. Earlier this year, the Second Department decided Deutsche Bank National Trust versus Spanos, and decided it a little bit differently than they decided Weisblum, even though in some respects it certainly didn't reverse the result. In Deutsche Bank, the defendant raised affirmative defense that the plaintiff failed to comply with 1304 notice requirements. In its motion for summary judgment, the plaintiff did not include the affidavit of service evincing that it complied with the 1304 notice and therefore failed to meet its prima facie burden of establishing its entitlement to judgment as a matter of law in connection with this affirmative defense, reinforcing the significance of this notice as part of the prima facie obligations a plaintiff has to obtaining foreclosure. The court therefore held that the motion for summary judgment should have been denied without regard to the sufficiency of the borrower's opposition papers. However, in this particular case in the Supreme Court, before it got to the appellate division, the defendant's cross motion for summary judgment was based on plaintiff's failure to comply with the 1304 requirements. And the court said that the defendant's cross motion should also have been denied because the defendant relied in her cross motion solely on her attorney's argument that the plaintiff failed to submit proof. The defendant's failure to submit a sworn claim that she did not receive the notice required denial of her cross motion. And while that makes sense, the attorney is not in a position to provide personal knowledge of whether or not the notice was served or received and what the contents were for that matter when it was received. The problem I have with that is that under the CPLR Rule 3212, which governs summary judgment motions, if it shall appear that any party other than the moving party is entitled to a summary judgment, the court may grant such judgment without the necessity of a cross motion. So the question becomes, and if you go back to Weisblum, Weisblum did not make a motion for a cross motion for summary judgment. and the case was dismissed by the second department. Here, if the defendant had adhered to the phrase less is more and not done a cross motion but simply opposed based on the plaintiff's failure to evince its compliance with 1304, the court, I believe, if they were consistent and followed their previous ruling in Weisblum, would have actually dismissed the action. Here, they just kind of deny it and allow both parties to sort of regroup. But it just raises an interesting question for me, just in terms of how the procedures work with these, because we're talking about notices, again, that are delivered, some of them have to be sent, the 90-day notice has to be sent before the complaint is served, the 1303, and now the 3012-B notices, the certificate of merit, and the colored paper notice are kind of attached to the summons and complaint. They're really not part of the factual allegations and the factual grounds for actually, whether or not there was a default or not. So it's kind of interesting how that works. Stern Obstfeld v. Bank of America, I'm not going to spend a lot of time on it. Sufficient to say that it's a case that extends the requirement for 90-day notice and its condition precedent and its strict compliance requirements to the area of cooperative apartments, where there's a non-judicial foreclosure of the shares of stock in the co-op under the UCC Section 9-611. The secured party must send to the borrower a 90-day notice, and the court holds that this predicate notice is a necessary requisite to maintaining the action and would result in dismissal. Contractual condition precedents, going back to the original definition in the restatement of contracts, the primary contractual conditional precedent is found in Section 22 of the standard Fannie Mae Freddie Mac Uniform Mortgage Instrument, involving the lender's right to accelerate the entire debt upon a default. Section 22 of that standard Uniform Mortgage Instrument requires that for the lender to require immediate payment of the entire amount due under the note and mortgage requires that certain conditions be met, including basically that the lender must send a notice as required under Section 15 in the mortgage instrument that identifies the default, notifies the borrower of his or her right to cure at least 30 days prior, and that failure to cure will allow the lender to require immediate payment of the remaining balance in full. This must be in writing. It's considered as given when mailed by first-class mail or when delivered by other means. And notice to one borrower would be sufficient, unlike the statutory notice requirement for 1304, which has to be sent to all the borrowers as well as the tenant. There is actually a case that goes back to 1994 that involved, if not this exact mortgage instrument language, then something similar. And it was a Supreme Court case from Rockland County, Manufacturers and Traders Trust Company versus Korngold. Excuse me. Pursuant to the mortgage, the lender is required to send the borrower a 30-day default notice as a condition for accelerating the mortgage debt. Notice was given not by Manufacturers and Traders Trust Company as the plaintiff, but by Midcoast Mortgage Company, which was neither lender nor its successor in interest. The court held that the contractual condition was not met, and thus acceleration of the mortgage is precluded. The court cited to Real Property Law Section 254 language there that states wherein written notice is to come from the mortgagee or its obligee, its executors, administrators, successors, or assigns to support its ruling that Midcoast Mortgage Company, neither lender nor successor nor administrators or assigns, was the valid party to serve this notice. And the language in the mortgage makes clear that it's the lender or its successors and assigns who are required to serve the notice. In this particular case, the plaintiff actually tried to provide evidence that Midcoast did have the authority to serve this notice as an agent of the plaintiff. And they submitted evidence consisting of an affidavit from the vice president or a vice president of Midcoast, claiming that it is the agent for the plaintiff. And the court noted that Hornbook law states that an agent's authority may not be proven out of the mouth of the agent. The court noted where the mortgage expressly requires the lender to send a notice of default, proof of an agent's authority must be exhibited to the borrower. The plaintiff cannot, and then there was a case actually out of the Second Department back in 2002 where the court held that the plaintiff couldn't establish through conclusory allegations by its attorney that it served the predicate notice required by the mortgage. Although the contents of the predicate notice satisfied the requirements of the mortgage instrument, and the summons and complaint constitute a proper acceleration of the mortgage debt, the plaintiff's failure to establish it was served in accord with the mortgage results in a denial of its motion for summary judgment. What's important, again, is that the contents of the notice and the service requirements of the notice both must be met. If one's not met, you have a compelling argument that the matter should not, that the plaintiff should not succeed. I think that, okay. So with that, I thought I had, bear with me. Oh, here it is. Okay. I just wanted to point out I actually skipped the slide. So Siegel versus Kentucky Fried Chicken is the Court of Appeals speaking in a summary eviction proceeding where involving a notice to terminate a written lease. And pursuant to the default provisions of the written lease, the landlord must serve a written 5-day notice, and that's effectively the notice to cure requirement in a landlord-tenant proceeding. The predicate notice in this particular situation given under the lease was signed not by the landlord, but by the landlord's attorney. And the Court of Appeals held that where an attorney not named in the lease and with whom the tenant had never previously dealt were insufficient, and the tenant was entitled to ignore them as not in compliance with the lease provisions concerning notice. And that goes back to, it basically is where the Supreme Court in Korngold got its rationale. The agent, someone claiming to be an agent by itself is insufficient, and as far as predicate notices are concerned from the contract, whether it be the mortgage or in this particular case the written lease, if the language in the agreement says it must come from the party not breaching the agreement, so in this case, in our cases, foreclosure actions, the plaintiff, then there must be some proof of authority attached that can't come from the agent itself. What is really unanswered by these cases from long ago in the 20th century is what proof of authority is necessary in this day and age. May mortgage servicers, because most of our cases at this point in time you'll see these notices are issued by mortgage servicers. The mortgage servicers are really the ones fueling the foreclosure actions, even if they're not named as the plaintiff. May they serve the notice of acceleration or any other predicate notices that are required. Clearly under the statutes that I cited to earlier, 1304 in particular, it states that the mortgage servicer is one of the parties authorized or institutions authorized to serve the notice in the statute. So I think that the agency question is already built into the statute effectively. And as far as the service of the notice of acceleration from a mortgage servicer who otherwise might not submit its power of attorney, for example, the Court of Appeals in its rationale in Siegel versus Kentucky Fried Chicken states with whom the tenant had never previously dealt. Well, in a lot of these situations, the homeowner borrower has dealt with the mortgage servicer. They might have made payments to them before they defaulted. They've received statements from them. They might have interacted with them in trying to seek a modification. So I think the jury is somewhat out on whether that would be sufficient proof to establish the agency in the right of the mortgage servicer to serve that notice. Okay. In the time remaining, I kind of want to shift gears just a little bit and focus on some of the issues I see in complaints in foreclosure actions. CPLR 3013 talks about the particularity of statements generally, and statements in a pleading shall be sufficiently particular to give the court and parties notice of the transactions, occurrences, or series of transactions or occurrences intended to be proved and the material elements of each cause of action. CPLR Rule 3014 states that every pleading shall consist of a plain and concise statements. The basic requirement for pleading is to give notice to the other side of the transactions or occurrences. The court's inquiry, if a pleading issue is raised, is to ask whether the total verbiage of the pleading at issue may be said to give notice to the other side of what the pleader's grievance is. If, from its four corners of the complaint, factual allegations are discerned which taken together manifest any cause of action cognizable at law, a motion for dismissal will fail. And then it also notes that, and that's a case from the Court of Appeals in 1977, and it cites that evidentiary material is considered. The criterion is whether the proponent of the pleading has a cause of action, not whether he has stated one. And unless it has been shown that a material fact is claimed by the pleader to be one is not a fact at all, dismissal should eventuate. Since a party doesn't have any foundation in law or fact to foreclose without establishing its legal or equitable interest, the plaintiff's motion for default judgment in this particular case must be denied. That was a case out of the First Department in 1998, and there was a case out of Suffolk County in 2007 that said the same thing. Where a complaint is verified by a plaintiff's attorney, which is what I see almost exclusively in the foreclosure complaints that we see here on Long Island, and then the affidavit in support of the motion for default judgment was from an alleged but unproven attorney in fact. In other words, an employee of the mortgage servicer, but there's no power of attorney attached. Then the plaintiff under CPLR 3215 cannot obtain a default judgment. Plaintiff's summons nor their complaint. This is a Third Department case from 1999 where the plaintiff's summons and complaint failed to include a description of the property securing the mortgage. And to obtain jurisdiction, a particularized description of the mortgaged property must be included and the failure to do so resulted in dismissal of the action based on the defects in the complaint. And I've gone through all these sections of the CPLR in these cases because of what I see in the summons and complaint, which are sometimes overly generalized. They will claim that the plaintiff, who is not the original lender on the note, is the holder of the note and the mortgage, and they'll also allege, a lot of times they'll conflate it and imply that the note was transferred to it somehow through just the assignment of the mortgage. They'll have an allegation that plaintiff is holder of the note and the mortgage. They won't state how they're holder of the note and mortgage, but how they're holder of the note, how they came to hold the note, whether they were given the authority by Fannie Mae or Freddie Mac, for example, or whether there was a proper transfer under the UCC or whatever. But they will claim implicitly, they'll say we are that way because of the assignment of the mortgage. And that, to me, is not sufficient. A lot of times I also see, and I realize this is a topic for a different day, but where there's a copy of the note that's attached, sometimes there'll be a blank, undated endorsement that neither shows when the plaintiff allegedly received this endorsed note. They'll claim they received it prior to the commencement of the action, but they won't say exactly when. And it becomes, from my perspective, representing defendants, very difficult to know how to respond to that, because I can take it at face value, but if I take it at face value, there's no evidence or there's no allegation as to when they've gotten it, and how they received it as well. And I think that there may be an argument there. There are two Supreme Court actions, United States Supreme Court actions, that were decided in the last 10 years that talk about the sufficiency of a federal court pleading. And in both these cases, the Supreme Court has effectively, as far as federal law is concerned, reversed the trend for more liberal pleadings in the federal context to require more particularity. And Federal Rule of Civil Procedure, Rule 8, requires the complaint to contain a short and plain statement of the claim showing that the person is entitled to relief. And if you compare that with language in CPLR 3013 and 3014, which talks about sufficient particularity and plain and concise, they're very, very similar. And there tends to be in court cases a sort of cycle. When courts rule and they feel they've gone too far one way, they tend to backtrack on some of their precedent in subtle or not so subtle ways. And I think what's gone on in the federal sphere is that there's become more of an onus from the Ashcroft and the Twombly case from the Supreme Court to require plaintiffs in federal court to provide more particularity in their complaints. And I think there's an argument that a similar case can be made in state court under the CPLR, and where, while generally I think plaintiffs can plead in the alternative, and they do not have, there's a distinction obviously between alleging in a pleading and establishing through proof. I think that there's an argument to be made that some of these complaints, bare-bone complaints that are signed by attorneys, not the party, may have weaknesses that can be challenged. as the Supreme Court said, threadbare recitals of a cause's elements supported by mere conclusory statements do not have to be accepted by the court. Is the allegation in a complaint that the plaintiff is the holder of the note and the mortgage, yet where the complaint only then goes on to allege how the plaintiff came to be the holder of the mortgage but not the note, is that not just a mere conclusory statement of compliance? And I think there are arguments to be made along those lines to challenge the pleading. I don't know how I'm doing on timing. Becky, can you help me there?
Yep, we've got 5 minutes left.
So can we open it up for questions?
Yep, so far we don't have any questions. I just sent out another little chat to folks encouraging you to submit your questions in that little box here in this dashboard. But until then, I think you can keep talking. If one comes up, I'll interrupt you, Mike. Is that okay?
Yeah, if I have anything else to add. You know, I just want to, you know, again, I think the important things to note, you know, under the new law for the Certificate of Merit, obviously, that took effect, there's been no decision that I've seen that has discussed, you know, whether or not that, you know, how that's going to play out and how that can be raised when the plaintiff doesn't provide it. It can be a useful tool, I think, especially in the requirement that it really now codifies, for the first time that I've seen, something, even though not completely on point, but somewhat, that the plaintiff now has to provide the note and the mortgage at the time it serves the complaint. And to me, they would have to include, obviously, a proper endorsement if the endorsement is included, and you're in a better position to respond to it right up front. So even if these arguments, these claims, especially under the complaint, are not necessarily going to result in an outright dismissal, I do think it kind of puts more of the onus up front, the timing of the onus, on the plaintiff as to when they have to provide certain information, how they have to provide certain information, both in the complaint and in predicate notices. And it gives us, in representing homeowners, an earlier opportunity to see it and then to sort of plan out our strategy for how we're going to help the homeowner. And so hopefully the goal, the hope is that it will change the dynamic and, you know, requires more information from the plaintiffs, because I think that a lot of what I see in the complaints particularly is as little information as is possible, which I think they should be held to a higher burden, and hopefully the change in the law will help that in addition to these cases. And I think pretty much with that, I have nothing really else to add.
So we have two questions. The first one, I'll double check with you, Mike, but the question is, when did the new law take effect regarding the Certificate of Merit? I believe it took effect
August 30th.
August, right, filed after, on or after?
Everything, summons and complaints filed after August 30th. For cases that were filed before that, I believe the affirmation, the attorney affirmation required under the court rules would still be in effect. And I think that under amended court rules, a plaintiff who commenced an action before August 30th has the option to submit the attorney affirmation under the court rule or this Certificate of Merit.
Right. Okay, so the next question is, what about the language of RPAPL 1304, which suggests that the lender or servicer who commences an action must be the same party that sends the 1304 notice, not merely an assignee, etc.?
I don't know. Let me see. I have to find 1304. Where is that language in 1304?
I don't recall off the top of my head, Mike. I don't have it in front of me.
I mean, I thought that there's language earlier, notwithstanding any other provision of law with regard to a home loan at least 90 days before a lender, an assignee, or a mortgage loan servicer commences legal action against the borrower. I mean, I don't know the answer to that question. If it's like, in other words, is the question saying that basically if the mortgage servicer serves the 90-day notice, then it has to be the plaintiff? That's, you know, is that it?
I'm the best I can do is read it out loud. I'm not quite sure. So what about the language of RPAPL 1304, which suggests that a lender or servicer who commences an action must be the same party that sends the 1304 notice? So I think that's what.
I mean, if anybody else has any thoughts, you know, I think that, again, the mortgage servicer in in many situations can maintain a foreclosure action. Fannie and Freddie both have made clear in the past, in their guidelines that the mortgage servicer can sue in their own name. My understanding is that the purpose of the notice, I think the mortgage servicer can serve it on behalf of the owner without, just being the mortgage servicer. And I think that's a question about they don't need to establish any other authority as an agent. But I really don't know, unfortunately, how that would look.
She just followed up and said perhaps I'm reading another version of 1304. I don't know.
Well, there are two. There's language. There are actually two. In 1304, there's language like a Section 1 that is applicable until January 14th, 2015, and then there's a second Section 1 that takes effect on after January 14th, 2015. And that really just goes effective January 14th, 2015. The only real change in the language there is the required notices will revert back at that time to the high cost or subprime loans. And you won't need to give a 90-day notice if the loan is neither of those.
Right.
But I'm sorry, I don't have an answer.
I think sometimes this is the downside of having just through text. So, anyways, Mike, as always, thank you for your help and support in this little project that we have to try to do these webinars. And I appreciate everybody sitting in and listening. It was certainly helpful to me. Thanks, Mike.
Thank you. Thanks, everybody. Bye-bye.
Bye, everyone.
One last thing, the CLE code for today is 4865N. That's 4865N. Thanks, everyone.